Hello, welcome to the Disability Law Question and Answer session, Q&A. My name is Martin Willemse. I am a partner at the firm of Samfiru, Tumarkin, and I'm the Western Canada Disability Practice Leader, meaning we operate in British Columbia, Alberta, and we have an office in Ontario as well. So we operate through these three provinces. We handle long-term disability claim denials, other insurance claim denials, like, for example, critical illness and life insurance claims that have been denied. Uh, Contact information prior to us starting the session. Our disability website, it would be disabilityrights.ca. You can email us at help@disabilityrights.ca. And to find my contact information, scan the QR code that is being displayed on the screen. You can also phone us at 1855 821 5900. As you can see on the screen, we have the email address help@disabilityrights.ca for any questions that you may have with respect to an ongoing disability claim, or if you're contemplating filing a disability claim, or any questions that you have with respect to yourself or family members whose claims may have been denied. You're welcome to ask us any questions during the Q&A session, which is now. So simply just type your questions and I will respond to those questions as they come up. Uh, Generally, in terms of what is a disability claim and what does total disability mean, most people who are employed have disability insurance through their employers. So there may be a group policy in place. The group policy may provide for short-term and or long-term disability benefits. The phrase total disability means, in terms of a contract, not necessarily what it means in terms of a layperson's idea of total disability, or even when doctors understand what the term of total disability means. In terms of a long-term disability contract, that phrase or that term specifically refers to a person's functional impairment with respect to what they are able to do in their place of employment, in their occupation. So total disability in terms of a contract means you must have an illness or a condition that prevents you from performing the essential duties of your own occupation. And after a period of time, generally after 2 years, sometimes it may be 1 year, sometimes it may be longer, depending on the terms of the policy. It may be that if it's a 2 year time frame, if you're still disabled and still unable to perform the duties of your own occupation, the definition then switches to that of any occupation. What does that mean? We have questions about that on our show regularly because we also do a radio show and a TV show. It's referred to as the change of definition phase. When the definition changes, any occupation does not literally mean any occupation. You have to prove that you still have functional impairment due to an illness or an injury that prevents you from performing the essential duties of any other occupation. And this is the important part, based on your education, your training, and your experience. So if that is the case, and we generally would have doctors involved in these cases, where your doctor would support your claim for total disability into the any occupation phase. That is where we see that most cases are denied at the change of definition. Many people understand, and so do doctors, that any occupation means that you have a disability that prevents you from working any conceivable occupation, which is not the case. It has to be something for which you have the transferable skills. Here we have a question. How frequently can your insurer request a review to be done on your file? My sister seems to have a constant review process going on. You know, again, we go back to the terms of the policy. The insurance company also has rights under that policy, and the policy provides that the insurance company can review through what is called an independent medical examination a claim, but it has to be done on a reasonable basis. I'm not sure what the review in this case refers to. If it is the insurance company wants to have what is called a functional telephone interview, they do that on a regular basis. If it becomes overwhelming, might it be a good idea to put everything in writing to confirm what the insurance company is saying to you in writing by email, return email, because quite often they do record conversations And at your end, you may be able to do that through taking notes and confirming to the insurance company in writing what has been said. If it becomes too much, if the review is constant, in other words, if they are constantly on the phone with you, or if they're wanting to send you to more and more medical examinations, that would be too much. And I think that they would be stepping outside of the terms of the contract. In a case like that, have your sister reach out to us and we can review her situation. We do offer free consultations on this on a regular basis. And we review denial letters, appeal documents, um, medical documents, the policy itself to see what your rights are under the policy. We have another question from Laura. I will soon have to go from short term disability to long term disability due to a neurological disease. What could I do if the insurance denies that? Short term disability is based on your inability to perform the duties of your own occupation. Long term disability for the first 2 years, if it is a 2 year own occupation phase, would have the same definition. If your claim is being approved during the short term phase and then transitions into a long term and the claim is denied, obviously that should not be happening. If your claim is denied, don't accept that the insurance company's decision is correct. Be in touch with us. Call us. We'll offer you a free consultation. We'll review the documents with you, the denial letter. We'll have a better understanding as to why it is that the insurance company is saying that your claim is denied. Um, Almost always there's something to be done. There are various ways to attack that decision, to deal with the denial itself. See your doctor on a regular basis. Make sure that your doctor records all your complaints in terms of what you are unable to do. Make sure that there's a paper trail of that so that if there is a denial later on and that denial has to be fought, we have to fight against that denial, then we can refer back to the paper trail, the doctor's clinical entries, and get the doctor on board to support your claim for ongoing total disability benefits. But if the denial is made, immediately be in touch with a lawyer who handles disability claims. Not to say that that is where you would end up, that because you do have other options as well, but getting an informed position, getting advice to make an informed opinion will go a long way for you. I have a question, but I'm worried I cannot afford legal advice. That's a good question. We offer, as a firm, free legal advice or legal consultations. So if your claim has been denied, or if you are being paid and you feel that the insurance company is putting you in a position that is creating further stress, or if you have questions regarding your rights while on claim, or if you're contemplating to make a claim, we do offer free consultations. So don't be hesitant, please take that opportunity, make the phone call, and we can discuss your claim with you. As I said, we speak to people on a regular basis throughout BC, Alberta, and Ontario with respect to denied disability claims, or people who still may be on claim, or feeling that the insurance company is pressuring them to go back to work when they're not able to do so. We can review your specific circumstances, your personal circumstances, and at least have a discussion with you about what your rights are and what your options are. Quite often we see cases where the insurance company would have said, we think your disability isn't really a disability. It is related to a workplace stressor. In other words, if you were to say you had a claim that was denied because the insurance company believes that your disability is related to a bullying claim, where there's a bully at work or there's harassment at work, and that has created a mental health illness for you. When the insurance company then says, well, we think this is a workplace issue, simply go work somewhere else. This is not a disability issue. Those are on the rise. Lots of cases like that. So if that does happen, insurance company is not correct on that front, unless it is that you say you are able to work as long as you cannot go back to that same employer, because that's a different situation. But do not accept that if a claim is denied because the insurance company says it is a workplace incident. That's not the case. It depends on the medical evidence. If you do have your doctor's support that you cannot perform the duties of your own occupation, regardless of whether the disability arose as a result of workplace bullying and harassment, or it was contributed to by workplace bullying and harassment, you still have a claim. The disability policy simply provides that you have to prove that you are unable to perform the duties of your own occupation, then you still have a claim. and that claim can be pursued through various avenues if there is a denial. If your insurer is asking for more than they are allowed to, what should you do about that? This is a question that comes from Rosemary. You know, it depends on what the questions are. We have had situations where, I will use an example, somebody who has various properties and they are renting them out, that the insurance company wants to have details about those. A disability policy is about functional impairment. In other words, your inability to work in your own occupation. They're entitled to evidence or information regarding your disability. In other words, getting medical evidence from your doctors, getting clinical entries, maybe getting information from your employer as well. Going far beyond that scope, it really does depend on what the information is that is being requested. Again, I would suggest get legal advice on that. It depends on what it is that they are asking for. But insurance companies quite often push the envelope. They want to go too far in those contexts. If it is a situation where it is too far, it may be helpful putting it in writing that you're not comfortable to provide this information. And further, ask the insurance company where in the policy does it provide for them to get the information that they are requesting if you feel strongly that it has nothing to do with the disability itself, with the medical evidence, or with respect to your employment, your education, your training, and your experience. So we have a question regarding ICBC. Unfortunately, we don't, I cannot, if ICBC agrees to cover a number of physio sessions, can they back out from those sessions once the settlement has been agreed on? Our Q&A session today is regarding long-term disability benefits and short-term disability benefits. I do welcome you to phone our office because we do have some some personal injury lawyers at the office who may be able to answer your question. The number to phone again is 1-855-821-5900. Another question that has come up is, how do appeals work? Why should they not be relied upon? You know, an appeal is a process that is offered by the same entity that denied the claim. So if your claim was adjudicated by insurance company X and they denied it, and they then offer you the opportunity to appeal that decision by saying to you, provide further medical evidence to us. We'll consider that evidence to decide whether we have to overturn our decision by offering you an appeal. The word appeal indicates that it is an appeal. You're going to have a third party, an independent third party, review your claim, which is not the case. It is the same entity that initially denied your claim that is now reconsidering it. I've seen cases recently, specifically last week, where somebody did engage in the appeal process. The claim was denied in November of 2020. The person filed 3 different appeals in the hopes that the insurance company will overturn the decision, trusting the appeal process, trusting that the insurance company will listen. When it came around to the final denial, the limitation period, which is a time frame within which you can pursue a legal claim, had expired. So you have to be extremely careful when you do decide to go down that road. And again, my advice would be contact a lawyer, have the claim reviewed to discuss your options. If you still want to go through with an appeal process, even after that discussion, you can do so, but at least get the information so you can make an informed decision. Carrie writes, my aunt has fibromyalgia, but she's been having a lot of trouble getting any sort of support. Should she have the support of a specialist to help her get some coverage? Um, this is a very good question, and it's a question that we have on a continuing basis. I just had a discussion earlier this morning with somebody else who is struggling to find medical care in a system that seems to be having a lot of issues with people accessing medical doctors, let alone a specialist. Your disability claim, if your aunt has a disability claim and she's struggling with respect to the fibromyalgia, or if she is thinking that she wants to file a disability claim, it is important to have a medical doctor on board, because doctors have to complete what is called an attending physician statement, which is a document that is filed in support of the claim. It does not have to be by a specialist, though. If you have a treating doctor who supports your claim to the extent that the doctor has been treating you for a while, is in a position to provide an informed opinion, supports that you are unable to work, in this case your aunt Carrie, if she cannot work and the doctor supports the claim, then she should file that claim if she feels she cannot work and if the doctor supports her. Having a specialist on board definitely will help, but it's not a requirement to have coverage in using the language that you've used. In order to file a disability claim, you have to have what is called an attending physician statement, an employee statement, which is the form that you complete, and your employer will provide a form as well, which is called a sponsor statement. The insurance company will then consider those statements, the application in itself, and decide whether they will agree to approve your claim or not, in this case, your aunt's claim. If your aunt is not seeing a specialist and is simply seeing a family physicians are also familiar with medical conditions such as fibromyalgia. You quite often see cases like fibromyalgia, chronic fatigue syndrome, which is also called myalgic encephalomyelitis, and other cases, other neurological conditions that are denied. The cases that are most denied, from my experience, would be ones that are defined or at least referred to as invisible illnesses. What that means is, or subjective conditions, what that means is that there is no MRI or CT scan or other objective measure to indicate that this condition exists or that the person has this condition. We know that fibromyalgia exists. We know that ME, myalgic encephalomyelitis or chronic fatigue syndrome, exists. But these cases, like mental health conditions like major depression, anxiety, PTSD, or bipolar disorder, many of those are also denied on a regular basis. Quite often, the insurance company would say, we do not have objective medical evidence to support that the person is unable to work. Well, if the doctor is agreeing that the person is unable to work because they have had the opportunity to see them on a regular basis and supports their claims that they are unable to work, and the insurance company then denies the claim, there is an opportunity to pursue a legal claim if there is a denial, or to fight that denial in another way. But simply because there is no objective evidence, it doesn't make sense to have a denial in place, and we can pursue legal claim against that. Carrie says they have told her that she had insufficient medical evidence and denied her because of this, which is basically what I've just said. So the insurance companies often would say that there is insufficient medical evidence or there is a lack of objective medical evidence. It's basically saying the same thing. There are subjective tests that you can use that doctors are familiar with to see whether a person has fibromyalgia. There are various doctors in place who could provide a diagnosis, and there are specialists. But the concern, again, in BC, and I'm sure in other provinces as well, is a lack of doctors and the long waiting lists. I'm going to venture a statement here to say that the policy doesn't require, there are very few who do, that do, but for the vast majority of cases or policies out there, the group policy or individual policy may not require as a term or a condition for total disability benefits that there must be objective medical evidence. There are some cases out there that will make reference to that, but ultimately, what is considered is the following. If the person is unable to work and has their doctor's support based on the medical condition. The diagnosis is important. In this case, it's fibromyalgia. It is important, but the diagnosis is only a small piece of the puzzle. The main issue, what is being looked at, is functional impairment. What are the restrictions and limitations resulting from the diagnosis, resulting from the illness? In a case for fibromyalgia, for example, it may be that, and it quite often goes hand in hand with chronic fatigue or chronic pain as well, that what are the medical restrictions, the functional restrictions and limitations, and that would often be, number one, brain fog, fatigue, chronic pain, diffuse pain, inability to sit, stand, or walk, uh, extreme fatigue, lack of energy. If all of these are detailed and supported by the medical doctor and supported by your aunt, the insurance company, unless they have something else to show that this is not a disability, to rebut what your aunt is saying, there is no basis for that denial. And again, my advice would then be get in touch with a lawyer, get in touch with one of us, who handles LTD cases, and we can assist with that. We handle cases throughout BC, Alberta, and Ontario. It's difficult to be in the situation where your claim has been denied. In other words, now you cannot work. You have a medical illness, you're not getting income, and you have to fight the disability claim with an insurance company while you have things like brain fog and depression and anxiety. Get somebody in your corner, speak to a lawyer, at least so you can understand what your rights and your options are. Here's a question from Arnold. Can my insurance be denied because I suffered my injury at work? I hurt my back on the job. This is a good question, and there are a few things to be understood. If you have long-term disability coverage at your workplace, and I'm going to assume that you do, make sure that you do apply to the insurance company for those benefits, even if your claim or your wage loss is being paid by WorkSafe BC or WorkSafe in Alberta. What that means is most LTD policies, long-term disability policies, will provide that certain things, certain other income sources can be deducted from what the LTD insurer has to pay you. And one of those would be WorkSafe benefits. So if your claim with the insurance company may pay you $3,000 a month and WorkSafe or WorkSafe BC is paying you $4,000 a month, of course, it basically wipes out that claim. But what happens if WorkSafe stops paying you? Then the insurance company would have to step in and cover what is not being paid if your claim still is in place. In other words, that you still cannot um, work, you're still disabled. I have seen a number of cases where a person did not apply to the insurance company because they assumed wrongly, either on the advice of their employer or some other person, or they just assumed that they didn't have to apply to the insurance company because their benefit is being paid by the WorkSafe provider. When the WorkSafe provider then stopped paying, the person then had to make a claim to the insurance company, and then the insurance company would deny the claim based on a time frame that had passed within which they had to file the claim. In other words, that the claim was filed too late. So make sure for anybody who listens, if you do have a workplace injury that causes your disability, make sure that you still apply to the insurance company so that they cannot later on say that your claim was submitted too late, because the contract, the insurance policy, has time frames, and it normally would be 30 or 90 days within which you have to provide notice of claim and proof of claim. Now consider a scenario where you've been paid for a year by WorkSafe, then they stop paying you. Now you want to go back to the insurance company to have your benefits instated. In a situation like that, the insurance company may say to you, well, you're out of time. We don't need to deal with you. You're too late. If that were to happen, again, please reach out to us. We have email addresses you can reach at by phone, 1-855-821-5900, to reach out to us to discuss whether you do have a claim, even if you missed a timeline. That is very important to understand. So there's a question regarding whether we have various lawyers handling other cases. Yes, we have a employment department, and the employment department handles cases throughout Ontario, BC, and Alberta. Quite often there's an overlap between disability and employment, and that's why we're in a very fortunate position at this firm, because we can give you advice on both. If your employment is somehow related to the disability, or if you get fired during a time frame that you were on disability, we can speak to you about that as well by having you discuss through a free consultation your situation with one of our employment lawyers. We have an email from Sinead. Are there any cases of insurance covering long-term effects of COVID? Again, a very good question, and it is so appropriate in the time that we are living. A disability claim. Say you have group policy through your employer with one of the big insurance companies. You find that due to COVID, long-term effects of COVID or long-term COVID, you can no longer work and you have your doctor support. You go off work and then you file a claim with the insurance company. Remember what I said earlier. Part of the diagnosis is a puzzle piece to the big picture. The most important thing is that you must have functional impairment, in other words, restrictions and limitations that prevent you from performing the duties of your own occupation or any occupation whenever that time comes. Very, very few policies rule out certain conditions. The vast majority of policies will provide that you must have an illness or an injury. Doesn't matter what it is. And if you have that and it as a result of that illness you have functional impairment, you can have a claim. So going back to that question, are there any cases of insurance covering long-term effects of COVID? In other words, are you able to file a claim because of long-term effects of COVID? Most definitely yes. Unless it is specifically ruled out by the policy, which it wouldn't be. I've never seen a policy like that. Yes, you can file a claim as long as you are unable to perform the duties of your own occupation or any occupation because of that condition. We have a question from Laura. If I'm on short-term disability paid by my employer, should I still contact the insurance company or I have to wait until the end of the short-term disability and then contact the insurance company for long-term disability? It's an interesting question. Quite often, the short-term disability phase would be paid by the employer but adjudicated by the insurance company. What that means is the insurance company's role is to consider the medical evidence and make a decision on the claim and then communicate that back to the employer who then pays the claim. If this is a situation where the employer pays short-term disability and also adjudicates the short-term disability claim, I would suggest make sure that you speak to your human resources as well. Get the long-term disability forms if it is going to transition into long-term disability, if you see yourself going off work into the long-term disability phase, because some LTD policies do provide that you have to submit notice of claim and proof of claim from the date of disability, where others would provide that you have to submit proof of claim after the elimination period had expired. What that means is the elimination period is quite often the short-term disability time frame, be it 90 days or 120 days or 119 days. And then after that period, you would have to advise the insurance company. I would, to be on the safe side, suggest that you make contact with the HR and probably with the insurance company as well to make sure that you do not miss the timelines within which to apply, because there is notice of claim provisions. In other words, they have to be informed of the disability claim that may be coming, and also proof of claim, which would be submitting to them the employee statement, which is the document you have to complete in support of your LTD claim, the attending physician statement, which is the form your doctor has to complete in support of the claim, and also the sponsor statement, which is the form that your employer will send directly to the insurance company. Those three documents generally would make up the application, and you don't want to be in a situation where you've missed, like I was saying with the WorkSafe BC claim earlier on, that you've missed the timelines, the notice of claim provisions, and the proof of claim provisions. I have seen a bunch of cases where people have missed the timelines due to specific circumstances, and the insurance company would then say, well, we cannot pay your claim, or we cannot even consider your claim because you've missed the timelines. In those situations, again, please reach out to us, because there are ways, depending on the circumstances, to deal with that denial. There's a legal principle called relief of forfeiture, which is not something that I will explain in detail now, but if you've missed timelines and there is a good reason why you did, even if it is more than a year, still speak to one of us, because we can review the case, we can review the application, we can review the policy, and give you an informed opinion as to what your options are. I have been, and I know my team members have been successful in pursuing legal claims with respect to claims that were denied because somebody missed the proof of claim provisions, the timeline, and the notice of claim provisions, the timeline. There's always a way, at least consider what the options are. Do not give up. It is a very stressful situation to be. And if we were to speak about appeals again, uh, if you find that you want to submit an appeal, which is not something that we would normally recommend, but if you did do that, just be wary that there is the limitation period that is running. That is the time frame within which you can pursue legal action. And that time frame runs throughout the period that you are pursuing an appeal. So that's something to consider. There's also something which we see a lot of these days um, that are contractual denials. For example, the notice of claim and the proof of claim provision denials, but something that deals with pre existing conditions. That is a whole nother discussion, and I don't think we have enough time to speak about all of that today, but I'm going to deal with it in the way that I can. Pre-existing condition, when you hear that phrase in layman's terms, means that you had a condition in your past, and the insurance company is now saying to you that if you're filing a claim based on that pre-existing condition that you had before, we don't have to pay you. Many people think that that's right and that there's nothing to do about that. That's not necessarily the case. I have a number of pre-existing condition denials in my caseload, and so do the lawyers that I work with. Pre-existing, a pre-existing condition is a contractual term, like total disability is a contractual term. Pre-existing condition denials quite often come into play if the person who's making the claim did not have coverage for more than for a year. So if you have coverage less than a year, insurance companies, based on the language of the policy, quite often would look at whether this disability is related to a pre-existing condition. Now, pre-existing condition, as I said, is a defined term. I'll use an example. If you've had depression for a long time, going back to your teens, and during your lifetime you've had some visits to a doctor or a psychologist or a psychiatrist, or you've used medication in terms of, or with respect to the depression that you've had, then you start working with with a new employer, and within the first year of having coverage, you go off work again due to depression. You submit a claim to the insurance company and they deny your claim based on a pre-existing condition because the understanding is you've had pre-existing condition for over a long period of time. Pre-existing conditions, as I said, is a defined term within the meaning of the policy. So an example would be if you've had treatment for depression during the first 90 days or the previous 90 days of your coverage, then it's pre-existing. If it's not, then it's not pre-existing. It depends on the language in the policy. Pre-existing conditions have a very, very specific window within which they can be considered pre-existing. And if it falls outside of that window, then it may not be a pre-existing condition within the meaning of the policy, even if you have had that condition for your whole life. It depends on whether you've had treatment for it and whether you were prescribed medications for it during a specific period of time. That's why it is crucial, absolutely crucial, that you consider contacting one of us to have your claim reviewed, the medical evidence reviewed, to see whether the insurance company is correct with stating that it is a pre-existing condition. And quite often it is not. You may have been treated, for example, for anxiety, where your disabling condition is depression, which means that there it isn't. At least that would be the position that we would take. So contractual denials, always based on the policy. Remember, it is the insurance company who's making the decision. It is the insurance company that's saying to you, look, we are going to deny the claim based on what we deem it to be a contractual denial, be it because you have filed your claim too late, or because it is a pre-existing condition, or because they may say that you have not had coverage with respect to the claim that you want to make. It is an overwhelming position to be in if you cannot have access to the policy or if you do not understand the language that the insurance company is using in its denial letters. Quite often it is confusing because they would be referring to contractual terms. They would be referring to specific deadlines and periods. And you do want to have somebody who is familiar with disability policies and insurance denials to review that with you. I speak to people on a daily basis with denied disability claims. And even if there is a situation where we cannot help, it does go a long way, I believe, for somebody to have a discussion with somebody who is familiar with this, at least who could give them advice as to what their options are. And if there really is no claim, which is not often the case, then we can at least provide the person some peace of mind as to that they've had a discussion to understand what their rights are. Speaking about peace of mind, many policies are out there, but a disability policy is what is called a peace of mind contract. It's a peace of mind policy. What that means is that you have contributed through your employment, or if you bought a individual policy through a broker with an insurance company, you have purchased peace of mind. That is the whole theory behind it. So that if the day comes, hopefully it doesn't, but if it does happen, that you are unable to work, that you have the peace of mind of having this coverage in place so that the insurance company will pay you your benefits, be it short term or long term disability benefits. And if you are denied, that peace of mind is now in jeopardy, of course, because the peace of mind that you had that I will have the security blanket, that if I cannot work, that I will have the financial security, has been ripped out from under you. So depending on the strength of your claim, depending on the circumstances of the denial, depending on what has happened, there may be a claim for what is called damages as well, be it aggravated damages, which would be an award made by the legal system, the courts, if the circumstances lend themselves to it because of mental stress that the person has suffered. There may also something which is called punitive damages, which the courts may use to punish an insurance company for the denial, not necessarily to award the person, but to punish. The punitive damages award is made to dissuade insurance companies from engage or others from engaging in that type of conduct. Again, not all cases will attract damages, but it depends on the circumstances of each and every claim. I have a question from Marcus. If my boss's boss threatened us in a team meeting after the second manager we had was fired by HR reasons because we spoke up, is that retaliation? Basically said if we don't get it together, then our jobs will be moved overseas, and it was in a team meeting, have witnesses. It's a good question in terms of an employment situation. I would suggest that you, Marcus, get in contact with our team who, because we've got a lot of team members, lots of lawyers in BC, Alberta, and Ontario who handle employment cases, be it a constructive dismissal claim or if there had been some other source. Please ask one of our lawyers so you can answer tomorrow. We've got, Marcus, just so you know, we have another Q&A session tomorrow with one of our employment lawyers at 1 p.m. PST or 4 p.m. EST time. So BC time, tomorrow we have Darren Saul on who can give you information on that. So please log in at that time and ask Darren that specific question. Again, fortunate that we have a team who can assist with both employment and disability questions. And on that point, again, not just employment and disability, we also do other insurance cases like critical illness and life insurance cases, which also get denied for various reasons. Remember that when you have a claim, be it based on critical illness or be it based on a life insurance benefit that you're entitled to, or be it based on long-term disability or short-term disability, all of these originate from a policy. And these policies are contracts. And contracts quite often form a source of dispute because we can argue about the interpretation of what a specific provision means. The insurance company will say it means one thing, we may say it means a different thing. So always wise to get in touch with an insurance lawyer to review your claim and to review the context of the denial or the benefits that you may have, that you believe that you have and you want to apply for, and just to get some information. Again, we speak to lots of people throughout the province in BC, Alberta, and Ontario with their denied claims, and we welcome anybody to contact our firm to at least have your claim reviewed. Thank you for tuning into our LTD Q&A. Again, the contact information, if you want to have further information and want to discuss your claims with us, visit us at www.disabilityrights.ca to discover your disability rights. The toll-free number is 1855 821 5900. Thank you for joining us, and by all means, tune in at our next disability Q&A, which we will be advertising soon.